We request all participants to please switch on their cameras and to kindly change their names to their team code. Good afternoon, Kajal ma'am. Uh, the teams are still joining and the other judges are also still joining. So we'll be starting at 4.
All right, thank you.
Thank you. To all the participants that are joining, again, I request you to kindly change your names to your UIC numbers and to your role so that we can score you accordingly. And please start switching on your cameras. Thank you. To all the judges, good afternoon. Thank you so much for joining. We'll be starting in another 5 to 7 minutes once all the participants have joined. Thank you. To all the participants whose partners are yet to join, please let them know that we're going to start at 4 o'clock sharp, maximum at 4:05. Please join by then. Post which we will close the meeting to other participants. Aroma, we can start at 4 sharp.
Very warm welcome to the oral rounds of the contract negotiation competition. I am Aroma and I'll be the host for today. Uh, Welcome to the oral rounds of the contract negotiation competition organized by the Delhi Legal Rights Consortium under the National Legal Rights Consortium, Women's Indian Chamber of Commerce and Industry. We are delighted to have all of you here today, our talented participants, our esteemed judges, and everyone joining us for these rounds. This is a wonderful gathering of legal minds, and we look forward to some exceptional negotiation today. To our judges, a very special welcome. We are honored to have you with us, and we are grateful for your time and expertise. Now that our honorable judges have joined, I'd like to request all participating teams to please confirm their presence. Each team has been assigned a unique identification code, your UICs. Following registration, this UIC is your identifier for all the rounds of the competition, and you will be addressed by it throughout today's proceedings. Could each team please confirm in the chat or raise their hands or confirm verbally that they are present along with the UICs? Thank you. We have all the teams accounted for and ready to proceed. I now request Kyra to please introduce the judges.
Thank you, Aroma. Um, I will first introduce myself. I am Kaira Mehra. I'm the Vice President of the Delhi Legal Rights Consortium. It is now my privilege and honor to introduce our distinguished panel of judges for today's oral rounds. Um, so first we have Kajal Arora ma'am, who is a legal counsel at a US-based AI-driven financial technology company where she advises on global commercial and procurement contracts across multiple jurisdictions. She holds an LLM in corporate laws from Nalsa University of Law and is a CIPP certified by the IAPP with professional interests in privacy, technology, commercial contracting, and the evolving intersection of law and emerging technologies. Next, we have Vasundhara Dhar ma'am, who is a dispute resolution lawyer based in Mumbai and currently works as an associate at Aquilaw. A gold medalist graduate from the Birla School of Law, she advises and assists on matters relating to commercial litigation, regulatory disputes, and infrastructure related conflicts. She is particularly interested in constitutional values, policy reform, and the intersection of law and technology. Next, we have Pranavi Ayagiri ma'am, who serves as a National Council member at NLRC WICCI with experience in corporate legal advisory, regulatory compliance, and commercial law across diverse sectors. She has worked with organizations such as Pidilite Industries, where she where she has continued to contribute to labor law compliance frameworks, consumer protection matters, contractual analysis, and regulatory risk assessment. Her work reflects a strong focus on practical legal problem solving and particularly in navigating complex commercial and regulatory environments. We are truly fortunate to have such distinguished practitioners and experts evaluating our participants today, and I believe that they will truly have learned something from the feedback that they provide. Thank you all for being here. Aroma, please continue.
Before we commence, I will now walk everyone through the rules that govern today's oral rounds as set out in the DLRC competition rulebook. The rounds are conducted in a knockout format. Two teams will be paired and will negotiate against each other before the judging panel. Each team has been assigned a party, either party A or party B, and must negotiate strictly from the perspective of that assigned party throughout the session. Teams may not voluntarily switch roles at any point. The mandatory settlement requirement, is perhaps the most critical rule of the oral rounds. Both teams are required to reach a settlement agreement before the end of their allotted time. The settlement agreement must address all material issues in the scenario. Partial settlement, one that leaves the core issues unresolved, will not be treated as a complete settlement and will attract penalties. Final agreed terms must be announced orally before the judges at the conclusion of the round and must be coherent, legally sound, and mutually acceptable to both parties. Time allotted is 30 minutes in total. Each oral round will run for a total of 30 minutes, structured as follows. The opening phase, which will last for 5 minutes, will be the minutes 0 to 5. Each team will present their initial position and key interests. This is your opportunity to lay the groundwork for the negotiation ahead. The active negotiation phase is for 15 minutes, which will be your minutes 5 to 20. This is the heart of the round, the live negotiation. Teams will engage in interest based bargaining, address counter arguments, and will work towards a settlement. The settlement announcement phase will last for 10 minutes for your minutes 20 to 30. Final 10 minutes are reserved for finalizing and announcing the settlement agreement before the judges. The terms must be stated clearly and completely. Teams are strongly advised to manage their time carefully. At the end of 30 minutes, they may seek for the judge's permission for an additional 5 minutes to wrap up. A reminder to all participants, please maintain the highest standard of professional conduct throughout. Any disrespect towards the opposite team or the judges panel will not be tolerated. Should the judges wish to offer any feedback to the teams at the conclusion of the round, we would be delighted to facilitate that. We will check with the judges at the end, and if they are amenable, we will open the floor for a brief feedback session. This is entirely at the judges' discretion. For round one, I would request UIC 05 representing party A and UIC 01 representing party B to remain in the meeting, and the rest of the participants would be called upon once this round is concluded. Kindly be on standby and ready to join. I repeat, I would request Party A UIC 05 and Party B UIC 01 to remain in the meeting, and the rest of the participants to leave the meeting and they will be called upon once the round is concluded. Okay. With the rules now explained, I would like to seek the permission of our honorable judges to formally commence the round. Your honors, with your permission, may we please begin?
Yeah, you should proceed. Yes, please.
Your honors. UIC 01 and UIC 05, you may begin. Your 30 minutes commence now.
Actually, before the opening statement, I would like to say something, ma'am. Like, due to unwavering situation, I already informed to one of the teammate, I guess, Prachi, that I can't on the camera. Like, I explained my
Uh,
whole issue to
UIC
her.
105 05, we know of your issue. That's all right. The judges will be informed duly. Please continue.
Sure, ma'am. Uh,
James, you may start now. Your 30 minutes start now.
Good evening, respected judges. Uh, Good evening, respected judges. I am the launch representative of Party B. We appear on behalf of the Party A, Dr. Amrita Gill. Um, I, the speaker one, and together with my colleague speaker two, we appear here today as a counsel for Party B, Dr. Amrita Gill. So, at the outset, we wish to clarify that Party A approaches this negotiation in good faith and with a genuine desire to achieve a practical and lasting resolution of the present dispute. With the permission of honorable bench, should I start with the opening statement, ma'am?
Please done. Yeah, please.
Yes, ma'am. Dr. Amrita Gill is a daughter of the late Mr. Robert Gonslaves. She is a professional based in Dubai, and she is a woman whose father, in his final act of love, left her the family home, the house she grew up in, the house with the well in the courtyard, the house on the east side of the 22-cent plot in the Panaji, Goa. This is not a claim she is asserting today. That's a right already vested in her by the validity executed will, by the law of succession, and by the Transfer of the Property Act. Further, we are not here to negotiate whether Dr. Amrita Gill keeps the house. We are here to negotiate the terms on which she will cooperate with the partition, because without her cooperation, there is no partition, there is no clear title for the developer, and there is no hotel. Here we are likely to point out the four issues. There are the four disputes before us today. So, firstly, the two sons deficient as Party B during their father's lifetime alienated 2 cents of the estate without the written consent, without a registered family settlement, and for his own private benefit to resolve an easement dispute that was his problem alone. He now wants the loss deducted from the common pool before the division. Secondly, the Munkar family. A family has lived in the outside. The family has lived in an outhouse on the west side, Party B's side, for over 30 years, and they have filed a declaration under the Goa Munkars Act. If they succeed, they can purchase the land they occupy at the nominal government fixed price. This is Party B's problem. He wants to shift it to the common estate before division. And here we kindly say it's their dispute, not the Party A's dispute. Thirdly, the novelty demand. Party B demands rupees 50 lakhs in cash, net of tax. Since Dr. Amrita Gill is an NRI, she is legally required under Section 195 of the Income Tax Act to deduct TDS at 20.8% on any such payment. Demanding the cash in hand is asking her to commit a statutory offense. The demand is illegal on its face. Fourthly, the excess easement. Mr. Rahul Pawar, a developer to whom Party B sold his share, wants a 6-meter commercial road through the south gate and the family mains entrance for the boutique hotel. Accordingly, according to the section 44 of the Transfer of Property Act, says that he cannot have it. A stranger to the family dwelling has no rights to possession as it's a statutory law. Here is party A's position in the three pillars. Firstly, we hold the injunction. Party A has filed for interim injunction under Section 44 of the Transfer of Property Act. The Delhi High Court, the Supreme Court, and every court has applied this provision, has said only one thing clearly: a purchaser from one co-heir cannot enter, occupy, or demand access to the dwelling house whether another co-heir resides. Here, Mr. Rahul Pawar is that purchaser. His 30-day specific performance clock runs against him and Party B, not us. Secondly, we hold the tax law. Dr. Amrita Gill cannot legally pay rupees 50 lakhs cash without TDS deduction. This is not a preference. It's a mandatory statutory obligation under Section 195 of the Act, of the Income Tax Act. Thirdly, the list pendants cuts both way. If Mr. Rahul Pawar files a list pendants notice under Section 52 of the Transfer of Property Act on the entire 22 cent title, Dr. Amrita Gill cannot renovate, mortgage, or sell her portion either. But we are prepared to wait. Mr. Pawar has 30-day deadline for specific performance. So the clock is his problem, like Party B's problem, not ours. Fourthly, the
In
settlement.
UIC 05, your opening phase has ended. The next 20 minutes mark the beginning of the settlement announcement phase.
I would like to ask 2 more minutes from the judges to conclude this opening statement, ma'am.
Can you finish it in 1 minute instead?
Yes, ma'am. Yeah, sure, ma'am. Lastly, we are realistic about this negotiation. We know Party B has leverage too, but let us to be honest about what the leverage actually is. The legitimate threat is not leverage. It's a 3-year litigation gamble that destroys Mr. Pawar's hotel project before the first brick is laid. And under Goa's CRZ2 regulations, the east sides cannot be developed anyway. So the gross value comparison that underpins the legitimate argument collapses the moment you factor in the development freezes. Party A is not an obstacle here. Party A is a key. Without her cooperation, there is no clean partition, no registered deed, and no clear title. So we invite Party B to accept that reality and negotiate on terms of the law will actually support. So we are ready to negotiate. Thank you.
Please.
Ma'am, I have
Yeah, please continue with the next. Yeah, can we have the next speaker, please? Yeah.
UIC 01, you can start with your opening statement, please.
Good evening. We represent Captain Rohan Gonsalves and Mr. Rahul Pawar. At the outset, our client wished to express their commitment to resolving this dispute amicably and avoiding prolonged litigation. While the will complements an equal division of the estate, the practical realities of the property raise concerns that require careful consideration. The eastern portion contains the ancestral residence, the only functional well and significant road frontage, while the western portion faces uncertainties arising from the historical Tucson alliance and the pending Mundaka claim. Our client's objective today is not to disturb Dr. Amrita Gill's enjoyment of the ancestral home. Rather, we seek a fair and workable arrangement that provides certainty to all stakeholders. Accordingly, our key interests are first, clear and marketable title to western portion. Second, practical and permanent access to that portion. Third, a fair resolution of valuation concerns so that future disputes may be avoided. Most probably, we wish to avoid inventory proceeding, injunction litigation, and year of uncertainty to all the parties.
To briefly supplement my learned colleague, our clients are prepared to explore flexible solutions. We believe that through cooperation, both parties can preserve family interest while ensuring that the western portion remains legally and commercially viable. We look forward to hearing Party A's concern and identifying common grounds.
Thank you, Your Council. Before discussing solutions, may we understand Party A's primary concern?
Party A, please respond.
The primary concern of Party A lays with the ownership of the ancestral residence as well as securing Party A's full enjoyment to 11 cents of the property. Party A is willing to provide the required ovalty, that is the equalizing payment, to Party B. However, their primary concerns, which they would like to emphasize, is full ownership of the ancestral residence. And a secondary flexible concern would be Party A's exclusive access to the South Gate.
We appreciate that concern and wish to clarify that our client is not seeking possession of the residence. However, given that the eastern portion contains the house, the well, and superior frontage, how does Party A propose to address the resulting valuation imbalance?
Party A would first of all, while we do appreciate Party B's need for equity in this situation, Party A would like to emphasize that the actual valuation of the ancestral residence as well as the attached plot posing an imbalance in the equal division of the property has, however, already been mitigated by, for example, the maintenance requirements on the ancestral residence attached to the maintenance requirements of the of the 11 or 10 cents of land that Party A will be receiving. Moreover, the Munkar claim on the property unfortunately overall affects the valuation of the total plot of land. This will not only affect the west side, but it will also be affecting the east side of the property and its valuation. This is because of one moment. This is because uh, suppose the Munkar family were to purchase that plot of land and any attached plot of land to their residence, to their dwelling house, it would have to be valued at the 1976 rate, which is the year in which the Goa Munkars Protection from Eviction Act was passed, 1976. The valuation of the plot of the dwelling house would be done at the rate of the rupee during 1976. And when adjusted against inflationary trends, that would result in only 30% of the original value of the dwelling house at 2026 market rate. So, as a result of all of this, I think it is safe to say that the value of the house will be decreased. So, and I would also like to emphasize that Party A is willing to provide an equalizing payment. However, the equalizing payment must take into consideration the fact that the maintenance and the long term heritage restrictions on the ancestral residence itself, as well as the Munkar claim, will be reducing the market value of the ancestral residence. Thank you.
Now, considering the situation, we are open to discuss alternative access. But, however, complete denial of practical access cannot be justified, right? Suppose, considering the Munkar issue, if now in this situation, Party A wants complaint indemnity in the case of Munkar claims, but this position is unfair, right? Suppose if this Munkar issue would have existed on the eastern side, would that Party A still argue that the entire burden relies on Party B or Party A only? I personally, our client personally feels that this estate is a common estate that has been alienated through our father. Why not we resolve it all together? Share half of the portion of the estate, share half of the Munkar claim. We do not want any dispute between us because our father has already alienated such property to us. And why not live a peaceful life, retain our ancestral property? West side is your property. I totally agree. But the other thing is that you, as Party A, relies heavily upon Section 44 of Transfer Property Act. Why? because party B is totally accepting that the stranger purchase cannot force any joint possession of a family dwelling house. I totally agree. But according to the alienated 22 cents, we as party B have already alienated our 2 cents of the property to Rahul Pawar, because it was my estate and I totally accept it. Rahul Pawar uh, sought our property. He is the outsider. You say that Section 4 of the Transfer Property Act cannot maintain any person and cannot let any person inside the house, right? Okay. Up till there is one estate and there is one will divided between us, and up till both of the party do not concern each other, any outsider cannot enter our house. But the issue is that Rahul Pawar, who has already given his consideration amount, is totally correct that he says that he has already paid the consideration amount and he has full right to enter the house. First thing. The other thing we say that in the case of Narsimha Murthy versus Sushila by 1996, it was said that a stranger purchase may be restricted from possession but continues to hold legal rights acquired through transfer. Therefore, Rahul Pawar's contractual interests continue to exist. The other thing, Rahul Pawar has already paid considerations, right? Our main concern is that he has already paid the consideration, and for a moment, if we think that if the settlement fails, at any point of the time, if our settlement fails, there will be three things that we both parties will suffer. The first is specific performance suit, the other is the inventory proceedings, and the third is the injunction litigation. Three separate proceedings, more costing of the same, more uncertainty, less value, total of the estate. Why? Because my property already has less value, which is why we are saying that the partition which according to the will has been divided may be referred to the court again. They determine what is the actual price of the will, and then it should be divided between us. And the other thing is, this is why we are preferring settlement, because we feel that settlement is commercially superior above the fact that there should be inventory proceedings on the top. We do not want, I have just sued the inventory proceedings. Why? Because I personally want that both of us maintain our estate, we live peacefully, there should not be any litigation proceedings. And final settlement offer from our side is that party A retains the ancestral residence. First point. Second point, party B receives western portion. The third point is that there should be regulated access rights granted, because we wanted the access from your side. Why we wanted the exit gate from the south side? Because our land is totally vacant, and if there is a hotel built there, that will be of no use, because our land has no commercial value, it has no superior value since it is a vacant land, and your land is towards the east, has more commercial value. So we just want that both of our exits, both of our lands have the same access. I do not want the whole access, I just want the shared access between both of us. The fourth thing is that the OLT compensation should be paid to us. The other thing, the main thing, that the Munkar liability shall be shared between both of us, because it's our state. I personally feel that both the burden and the debt should be bared by both of us. The other thing, that the Rahul Pawar's contractual rights should be recognized and all the proceedings shall be withdrawn.
Right. Point of clarification over here. The 2 cent alienation that occurred to your northern neighbor, the sale of the total west side was done to Rahul Pawar, but the 2 cent alienation was done to the northern neighbor. That was done without party B or party A's father's written consent, and it was done during his lifetime, if I am not wrong. So, according to Section 17 Clause 1 of the Goa Succession Special Notaries and Inventory Proceedings Act.
Excuse me, I cannot hear you. You are not audible.
Oh, sorry. Am I audible now?
Yeah, please.
Right. So, I was just seeking some clarification. The alienation of the 2 cents to the northern neighbor was done during Party B's father's lifetime and without his written consent.
Okay.
Yes. So, under Section 17(1 of the Goa Succession Special Notaries and Inventory Proceedings Act, the land was alienated without the father's written consent, and it reads, a co-heir is not entitled to dispose of any specific asset of the inheritance or part of such an asset to a stranger until and unless the said asset or part thereof is allotted to him in the partition. Any such transfer, if made, shall be inoperative and void. So I would, while Party A is completely willing to provide an equitable settlement of the Mulka claim in cooperation with Party B, Party A is still unwilling to let go of the full 11 cents required in order assess our client's entitlement. So we would like to know whether Party B would be willing to provide 1 cent of the land as is entitled to Party F, because the burden of such transaction, even if valid under the law, the burden of such transaction cannot be shifted onto Party A, especially when our client was not consulted in the alienation of this land, given that, as Party B has already said so, it was done in in a settlement of their own easement dispute.
Okay. To your
With the
question,
permission of 1 minute, with the permission of the judge, can I add up on one more statement regarding the Mulsker claim for the issue? So here, according to my learned co-counsel, said about the Munkar family's issue, why it matters is the Munkar family has been on the west side outhouse for the 30 plus years. If they get a Munkar declaration, they can buy that portion at the government fixed nominal price, I guess. Slashing the west side market value, this is the party B's problem. I again state that this is a party B's problem. He wants to move it to the common pool before division to reduce the east-west value gap. So here party A must block this. Accordingly, accordingly, with the reference of the case law, Lata Holkar versus State of Goa 2008, the Goa bench confirmed that Munkar's proceeding before the Mamladar are parcel specific. A Munkar declaration on parcel A creates no liability on the parcel B, even if the both are the part of the same larger estate. What I'm likely to say is the Munkar family resides in the outhouse of the west side. The 11 cents that falls squarely within the party's B allotment share under the will under Cafe Royal versus Fernandez and accordingly Lata Holkar versus State of Goa. A Munskar right to purchase attached to the parcel which they can reside. So it cannot be shifted to the common pool by private agreement. This is party B's encumbrances, his share, his risk, and his cost. So, likely to say that Party A is willing to accept a registered indemnity bond from Party B, covering all the Munkar cost and compensation, rather than demanding pre-settlement resolution. So, this is a generous commercial concession. So, using it as leverage to extract a concession on overity quantum.
may I begin? The legality, the thing, considering your thing, the legality and consequences of the transaction remain disputed and can be adjusted during final accounting. Even assuming liability, it does not extinguish Party B's inherent right. The second thing about the Munkar claim, the Munkar issue did not originate from Party B personally. It arose from the common estate and therefore should be addressed as part of estate valuation. The third, because Party 8 seeks to retain the sustainably more valuable asset, equity requires equalization where one heir receives a disproportionate share. And the other thing, Party B is not seeking more land, more money, or more power. He only seeks what every heir is entitled to under any law, an equal share in value, a practical share in enjoyment, and a settlement that replaces uncertainty with finality.
May I proceed, ma'am? So, regarding like under the Portuguese Civil Code 1867, as applicable in Goa by virtue of the Goa Daman and Diu Administration Act 1962, every person with forced hair can apply dispose and disposable quota by will. The non-disposable quota must pass to forced hair by operation of law. Okay. So here party B's agreement is the ancestral residence is equal to 70% of the total estate value by giving Amrita the house 70%. The will exceeded the disposal quota. She got more than she was entitled to under legitime. Therefore, the will should be reopened via. So party B claims this only. So here party A's argument is firstly net value is not equal to gross value. The east side carries CRZ2 restrictions. The house cannot be expanded, reconstructed, or commercially developed. It can only be repaired. A frozen asset is not a 70% asset in net present value terms. Secondly, a Munker devolution of west side. If the west side faces a Munker purchase, its market value drops sharply. You cannot assert a legitimate imbalance while simultaneously hiding that your own share is encumbered by the protected tenant with a statutory purchase rights. Thirdly, inventory proceedings timeline. As like inventory proceedings in Goa under the Goa Succession Special Notice and Inventory Proceedings Act 2012, which takes 3 to 5 years minimum. So Mr. Rahul Pawar has a 30-day specific performance window. These two facts are irreconcilable. Party B cannot pursue both simultaneously, I guess so. So, fourthly, the legitimate threat is a bluff. Like it's a party B truly believed that a legitimate argument would succeed, he would have filed already. He has not. So he is using it as a pressure and calling as an unequal distribution of property.
May I proceed, ma'am? Okay, so under the Portuguese Civil Code applicable in Goa, the concept of legitime protects compulsory heirs. Legitime is concerned with value and is not concerned with physical measurements. However, Party A repeatedly states that both parties received 11 cents each. However, equal area does not necessarily amount to equal inheritance. The east side contains the ancestral residence, existing construction, greater market value, and greater utility, whereas the west side contains vacant land, Munker uncertainty, access issues. Therefore, the economic value received by Party A substantially exceeds the value received by Party B. This is the reason why Party B has initiated inventory proceedings. The second thing, although Goa follows the Portuguese Civil Code, the principle recognized across succession jurisprudence is that compulsory heirs cannot be deprived of their legitimate economic entitlement merely through formal division. To the end of this conversation, to the end of this negotiation settlement between us, Party B only seeks that Party A retains the ancestral residence. Repeating again, Party B receives western portion, regulated access right granted, OLT compensation paid, Munker liability proportionately allocated, Rahul Pawar's contractual right recognized, and all proceedings shall be withdrawn.
With the permission of the judges, I would like to proceed to provide a bit of context to the point that you claim that the vacant land, that the west side, 11 cents, owned by by Party B, is vacant land and thus has a lower market value than what the east side has. I would like to the council would like to contend that due to the existing Munker claim on the west side, it not only affects the west side but affects the totality of the plot. And as a result of that, as my learned co-counsel had already mentioned, the CRZ2 restrictions, any expansion, renovation, or even commercial activity on the east side of the land has already been curtailed by way of the Munker claim along with the restrictions. And this is according to the Goa Munker Act of 1975. So the market value that Party B is alleging is not does not hold that much disparity. And Party A is willing to provide novelty. The question is whether the novelty will actually be representative of the real disparity as opposed to the alleged disparity. And as for access to the south gate, Party A requires exclusive access and is willing to provide access by way of the north to fulfill Party B's commercial interest, because it is. We would like to argue that there is no commercial urgency as to the access to the south gate for Party B.
We acknowledge that the claim concerns the western side and are prepared to assume primary responsibility for its resolution. We merely submit that the resulting reduction in value should be considered when discussing overall fairness, as well as our client's position is that the transfer secured drainage and easement benefits enjoyed by the state. Nonetheless, rather than revising historical disputes, we are willing to focus on a practical division moving forward.
Party A would like to reconcile as to whether Party B is willing to sacrifice 1 cent of its land in exchange for non exclusive access of the South Gate. and part settlement of the Munkar issue. However, Party A does require full 11 cents of the land as well as ownership of the ancestral residence in exchange for an equitable obality payment through the banking transaction as per section 195 of the Income Tax Act, as well as non-exclusive access to the South Gate.
Council will like to add one other point that party B's position like Munkar claims reduce west side value deduct from the common pool before division. So here likely I would like to say is under section 16 of the Munkar Act the right to purchase attaches to the parcel. As I already mentioned that where the Munkars reside the outhouse of the west side and the and the case law, Holkar versus State of Goa, has already said that they cannot be shifted to the common pool by a private agreement between the co-has. So, Party A does not require pre-settlement resolution of the Munkar claims. She accepts a registered indemnity bond from all the parties that covers firstly, all Munkar compensation purchase price. Secondly, all legal costs of the Munkar proceedings. Thirdly, any reduction in the west side value due to the Munkar declaration. So the bond is executed before the partition deed signing. So this is a commercially reasonable and legally sufficient accordingly with party A.
Okay. Our client Our client is willing to give up litigation rights today in exchange for certainty tomorrow. We believe that it is a fair compromise and the foundation of a durable settlement. The reality is that neither side can obtain everything it wants through litigation. Years of proceeding may determine legal rights, but they will not restore family relationships, reduce cost, or provide immediate certainty. Our client is prepared to make substantial concessions. We are willing to withdraw inventory proceedings, waive any challenge based on legitimate rights, and recognize Party A's exclusive ownership of the ancestral residence. In return, we seek only what is necessary to make the western portion meaningful, marketable, clear, excuse me, clear, and a balanced resolution of outstanding issues. Therefore, we respectfully submit that the most valuable outcome today is not a victory for either side, but a settlement that provides finality, certainty, and peace for all shareholders.
Uh, as reiterated, to reiterate what was said earlier, Party A will retain full ownership of the ancestral residence and is prepared to provide an OLT ranging from 20 lakhs to 30 lakhs in order to cover the equalizing payment. Moreover, the Munkar claim, however, needs to be settled solely by Party B, and Party A requires their 1 cent to fulfill their 11-cent entitlement as per the will. In return, Party A is willing to provide access to the South Gate and will no longer claim any exclusive access to the South Gate and will also withdraw the interim injunction under the Transfer of Property Act.
Party B shall withdraw inventory proceedings and waive any challenge based on legitimate rights. Both parties shall withdraw pending proceedings and cooperate in executing all partition and documents. Party B shall assume primary responsibility for resolving the Muntikar proceedings, but with reasonable cooperation from Party A. And the parties agree to a mutual acceptable balancing arrangement regarding valuation concerns. Thank you.
Thank you.
Thank you.
And that brings us.
Yeah. Sorry, Ramon.
Please continue, ma'am. Please continue, ma'am.
Oh, all right. So I understand you people have reached a settlement, but I think there's a few questions that I have. Where do we stand on the OLT payment? Because I guess one party said about 15 to 20 lakhs. Are we okay with the OLT payment of 15 to 20 lakhs?
Party A is willing to provide an novelty payment of 20 to 30 lakhs, subject to Party B's agreement on the same.
Party B, do we have an agreement on this as well?
Yes, ma'am. We are considering it.
All right. And what about the access rights as well? Do you get sort of a substantial right of access, or is it like just a smaller entry gate that you would get on the property?
No, party A suggests that we do not get the full rights of the South Gate, as
Yeah.
much as I have understand. But they say that we can. I think so that we can use it if with your permission. If we feel so that we are supposed to use it, we do not want whole substantial right, but just that we want whenever we should feel free, we can use it and nothing other than that. So yes, we are okay with it, ma'am.
Okay, but since the party is trying to, I guess, build up a commercial property on that same area, do you think would it be feasible for you to have a right of entry which is not that direct and probably indirectly impacted by the other party? What if they say that this particular gate or the entry gate would not be allowed to be used for this particular hours on this particular day? And since you are building a commercial property, do you not think this would like that be directly impacted because of that?
With the permission of the judge and the opposing counsel, if I may, while Party A has agreed to non exclusive access to the South Gate, that Party B, for his commercial interest, may access it, Party A is also willing to completely relinquish access over the North Gate of the property.
All right. Okay. And yeah, just one last question from my side, because I understand there were two missing cents as well. I understand that one party said that they would be willing to give 1 cent from their share. Does that mean that each of the party would be they are willing to give away 1 cent each for this missing 2 cents as well? Do we have an agreement on that too?
May I continue, ma'am?
Yeah. Yes, please.
Since Party A has proposed to give 1 cent to them in response that they'll be cooperating with the Munkar claim. Other than that, we'll be getting the non-exclusive right for the Southgate also.
Yeah.
Yes, ma'am.
Yeah.
So in return, I am totally agreeing to it that yes, everything from our side is clear. And regarding 1 cent, okay, we are okay to provide them with 1 cent.
All right. Okay.
Yeah.
Yeah, that's it from my side. Yeah.
Thank you so much, ma'am.
Thank you, ma'am.
Thank you, ma'am.
So that marks the end of round one, the UIC 01 and UIC 05. Congratulations on completing your negotiation. You both demonstrated tremendous preparation, composure, and skill. Regardless of the outcome, the craft you have brought to this competition today is something to be proud of. We wish you all the very best. A gentle reminder to our honorable judges, the score sheet has been shared with you via email. We kindly request you that please fill in and update your scores at your earliest convenience. Should you face any difficulty accessing the score sheet or have any questions, please do not hesitate to reach out to the organizing team directly. We will now begin with the second round soon. Participants for round one may leave the meeting. We have now called upon the second pair of teams.
To the judges, we will start the next round at 5 o'clock. If you so wish, please take a break till then. And thank you so much.
Thank you.
This
Can
is
are the other judges here as well?
yes, Pranavi, ma'am. You can go ahead.
Adrika ma'am, are you here?
Yes, yes, I'm there. Am I audible? Am I audible?
Uh, yes, Adrika ma'am, you are audible to us.
Okay. I think I'm not audible to Pranavi, ma'am, but it is just to bring to your attention that if the teams are not coming into a settlement, because this has been pointed out by Pranavi, ma'am, that if they're not coming to a settlement, so I mean, you can deduct marks for the same, because it has been many times told to the teams that you have to come to a settlement, and even if they are not coming to a settlement, then kindly deduct marks for the same. And I mean, yes, that is all that I wanted to
There's
add.
also I'm sorry, someone has joined. Um,
uh UIC 02, can you join in 2 minutes?
Yeah, so I wanted to ask about the Team 5 Speaker 2, I guess, mentioned this North Gate again and again, but in the hypothetical, we do not have anything written about the North Gate. There was just the South Gate. So here, I think the facts are being misrepresented to, add another gate and, resolve this situation like that. You can check the hypothetical. I never found any mention of a North Gate per se.
I'm so sorry, Pranav ma'am. Just a second. We'll just tell the other two teams that have joined
Okay.
to just leave the meeting for a bit. UIC 02 and UIC 04, could you please join at 5? We will send a message on the participants group. Yes. Sorry. Please continue.
Yeah, so what I said was that they also mentioned UIC 5 only. I don't know who started it, but they started mentioning a north gate, another gate to the property which they could, agree upon. But there is no mention of a north gate in the hypothetical. So I thought of pointing that out, but there was some miscommunication between me and ma'am, so we could not do it in time. So I also needed you to get a clarification as to why are they, yeah, okay.
UIC 04, could you please join at 5?
Yeah, so I also wanted you to ask other judges as well if they heard that, and I actually did hear that. So please get a clarification as to why did they mention that, and if it was, just a confusion or something, because this is misrepresentation then.
Yeah, I think the speaker number 2 of that team, I think team 05, that was the one that mentioned about the North Gate, because I specifically asked about this access rights question as well, and the answer was about the North Gate. Yes, but the facts do not point out towards any all gate. I think there's just one gate that is a South Gate. Uh, but yeah, I guess there's been a bit of confusion, because in my understanding, what they were trying to say is this, that they do not want to use the south gate, that they do not want to have the exclusive rights to that particular gate, rather use the north gate. But it still comes across as a bit of misrepresentation.
Actually, there's also one more thing that they did. They actually did not decide anything per se. They just mentioned their interest and they went on saying that it's an agreement.
Yeah, I think because they understand that as per the rules they have to come to a settlement, they started with a settlement rather than coming to a settlement.
Yeah, I no, no. I think when you ask them specifically that what did you agree upon when it came to OVLT, when only then they agreed that yeah, okay, we'll come to a common number. But
Yeah.
before that, the other party was saying 50 lakhs, and they were saying 20 to 30 lakhs. They kept on repeating that. There was no meeting of the minds there in a lot of points. So that is why I think a lot of their portion is missing of what they were supposed to come to. Okay, so I really thought it was a miscommunication or confusion. Now we can proceed. Now I know.
And I have one more question from the team. Where are we supposed to put our marks? Because I think me and Pranavi both are supposed to put their marks here only, or do we have different files for this?
No, ma'am. We've sent you respective score sheets. I can recheck if you want. Just a
Ah,
second.
all right. Okay. No worries. That's
They
okay.
have different
I think
pages
there
for other
is a
people.
Excel sheet,
Yeah.
and
Yes.
there are 3 pages for 3 of us respectively. So if you
Hmm.
just check those workbooks, so
Yeah.
I think I have added the marks according to the mark sheet given, and then it's coming total. So I think that is how it works. So just correct me if I'm wrong.
Yeah, I guess that's correct. Thank you so much.
Also, one more thing, there's some penalties that I wanted to ask about. I did not. What does unprofessional conduct mean?
Any unprofessional conduct, it could amount to anything that the judges deem fit, or in general parlance, we would understand that to be interrupting another speaker when they are presenting an argument.
Okay,
That sort of activity.
got it. Okay. Now you can proceed. Okay, thank you.
All right. Thank you, ma'am. We've informed participants to join sharp at 5, if that's all right with the judges.
Sure, no problem.
Thank you.
Till then, I request the judges to try and edit the file. If not, then kindly let me know. I can make the changes regarding to that.
Sure. Okay.
Kyra, please ask the participants to join. It's 5.
Yes, we are dropping a reminder.
I hope the judges did not face any issues with the marking the participants in the sheet.
No.
I'll have to update it after the round, so I can only tell you then. Is that fine?
Yeah, yeah, sure, sure.
Okay, thank you.
UIC4, we request you to kindly ask your partner to join as well and to
All
please
right.
switch on the camera. Yeah, thank
Yes.
you.
UCI 04 Party A, please switch off your mic.
Both teams have joined. I request all participants to have their cameras on. And then, Aroma, you can proceed.
Yeah, welcome back, everyone. I would like to seek the permission of our honorable judges to formally commence the round. Your honors, with your permission, may we please begin?
Yes.
Thank you, your honors. UIC 02 and UIC 04, you may begin. Your 30 minutes start now.
Party A, please begin.
Good evening, everyone, and thank you for being present today. My name is Eshu, and I represent Dr. Amrita Gill in this negotiation session. I would like to clarify that I'm here in an advisory capacity, and I will assist my client with the legal and technical aspects of the discussion. Any decision agreed or upon during this session will be taken by my client and shall be binding upon her. Will be and I'll invite Dr. Amrita to briefly introduce herself.
Good evening, everyone. I am Dr. Amrita Gill, Party A in this present matter, and all decisions I take in this session shall be binding upon me. Thank you.
Hello. I'm here only in advisory capacity. I'm here to assist Captain Rohan in any decision he is willing to make. Firstly, we would like to thank Dr. Amrita to come to this table to resolve the issues in a non-legal matter. And I would also like to clarify that our clients have come here with a completely good faith to dispute or to resolve this dispute amicably and avoid prolonged litigation. Thank you.
Good evening. I am Captain Rohan Consulates, and I'm here. I personally would like to thank Dr. Amrita along with her representatives. I really thank you for coming to this table to resolve this matter with an active negotiation rather than going and consuming our family in a prolonged battle of prolonged legal battle. I would also thank her for coming to this table, and I hope that in good faith we are able to come to a solution for this particular issue. Thank you.
So, at the outset, my client wished to clarify that our objective today is not to obstruct development or prolong family litigation, but to arrive at a fair and practical and commercially workable resolution. So, the late Mr. Robert Gonsalves consciously consciously bequeathed the ancestral residence to Dr. Amrita and through his will. So, our primary concern is to preserve his intention while protecting my client's ownership rights, privacy, and to reach a peaceful and fair resolution.
We completely agree to that. And Captain Rohan also respects late Mr. Gonsalves' will and testimony. And he does not want any possession of the dwelling house. He merely wants a clear title to his own site with uh, compensation that is duly deserved and also a access way to that property.
Adding on to what my counsel said, I respect my father's will, but what the will is there, what there is said that it is 50-50 equally splitted. That equal split is an illusion because the house, that is the ancestral property, holds 70% of the value. And I am left with a tenant claim, a Mundkar claim, and all the issues, and not even the road access and not even the functional will. So I come here to have a legitimate claim that my speaker that my council has said that I request that if I am given a good amount of OLT payment, that is rupees 50 lakhs as per the demands, we would be happy to resolve all the disputes on hand.
Uh, just to respond to that, I think that the claims that are on the west side that belongs to party B, especially referring to the 2 cent claim, that was a unilateral decision taken by party B without our father's consent. And I feel like it would be a little unfair of you to ask me to bear the burden of that. And as for the OLT payment, you cannot expect us to not obey the law and not follow the tax regulations that have been imposed on me by the Income Tax Act.
Okay, so two things. Firstly, the 2 cents which have been alienated, a drainage system has been constructed on it, and that drainage now benefits the entire 20 cents of the property. So this cannot be shifted on Captain Rohan solely. And secondly, we completely respect the law, and the quantum of the OVLT payment can always be negotiated. But before that, we need to resolve the issues like Southgate entrance, the Munkar issue, the 2 cent alienation, and also a clear title to the west side.
So over here, what our agenda over here is, thank you, Mr. Rohan and the Learned Council. What my client over here is trying to say that she want to preserve the ancestral residence and her ownership rights to the house, and west side belongs to Mr. Rohan. And second point is that the pending inventory proceedings and the legitimate claim, what Mr. Rohan has claimed, to be stopped if we give the easement access.
So would you be ready to give a 6 meter access that is unhindered and 6 meter access from the south gate? One, and the second is that OLT payment, because the house that is there has a 70% of value. So even if we do the tax compliance, we are ready to follow the law, and that with the tax compliance, we can get the 50 lakhs of OLT payment. Apart from that, if the third thing would be the 2 cent deficit. So as my counsel mentioned, that the 2 cent deficit is just not for the west side to benefit, but for the whole east state to get benefit. So and it is a historical dispute of the family. So when it is benefiting the whole land, the burden should not only upon me. And the last thing is the Munkar claim as well. So, what is your say on that particular Munkan claim?
Uh, about first of all, we'll talk about, as you said, about the OLT payment. So on what basis OLT payment is considered 50 lakhs? So my client would like to discuss about that also. And secondly, the two sin deficient, over that my client was not participant in that. There was no choice of her in this about student deficiency for the drainage. So it's completely unilateral decision. So so that part should be relied on Mr. Rohan.
Council, do you agree that this drainage which has been built on the two cents now benefits the entire property?
Uh, Miss Amrita would like to say something about that.
Yeah, just to add to what my counsel said before, just to respond to what Captain Rohan is also what he also said, that the fact that the house is at house makes up 70% of the value isn't completely accurate according to us, because the CRZ restrictions that are on the east side restricts commercial expansion, whereas the same is not the same for the west side. For the west side, which means that the east side has a lot of maintenance to do, and it's not exactly very profitable, but it does demand a lot of cash. And so we think that the OLT payment is not exactly fair, and it should not amount to 50 lakhs. And we would like if the opposing counsel would be open to a bit more negotiation. Secondly,
As
It was
yeah, please
also
continue.
about the drainage aspect. Like, is it helping right now to the residents?
Of course, it is currently helping the entire 20 cents of the property.
yeah, all right. Secondly, I was saying that we are willing to give you access to the South Gateway, a 6 meter wide access, provided that Party B gives me assurance that there will be a privacy wall built by your contractors, so that my enjoyment of the property and my ancestral home is also not hindered. And
Yeah, so as mentioned before, we are completely open to negotiating the amount of the OVLT payment. And we assure you a complete privacy, given that you give us a 6 meter unhindered part. Yeah, please continue.
um, I would specifically address Dr. Amrita that the house holds a very deep emotional and sentimental value for both of us. And since you have said that you require the house, I'm requesting that I should be given the not the legitimate claim, but at least the legitimate amount of money that I should require for that property. So my will was that my I was demanding for rupees 50 lakhs, but I would know your say on that. If you want to reduce it on less than 50 lakhs, we can have that as well, but not less than 40 lakhs or so.
Before we move to deciding the quantum of the payment for the OVLT amount, can we please discuss the Munker claim? Will you be ready to take a shared liability on the Munker claim?
The Mundakar is on west side. It's completely on west side, and it was from very previous time only when the Mr. Gonsalves was there. So my client would not wish to take the Mundakar claims situation in her hand over here, because that is completely on west side, and Mr. Rohan should deal with that.
Ma'am, as you respectfully said, that this issue has been there for a long period of time. This issue did not arose because of Captain Rohan, nor did it arose due to Mrs. Amrita. This
But
has
we,
been there since the time Mr. Gonsalves had the possession over the property. Now, it just happens to be that their house falls on the west side. It is not the liability solely of Captain Rohan. Hence, the liability of Munkar, if they are declared as Munkars by the court, then it needs to be shared equitably by both the parties.
but I would like to clarify that Mundakars were over there from past time, as you said, and Mr. Gonsalves was aware about that, and he did not wanted to, you know, make Amrita deal with her that stuff. So that is completely to deal with Mr. Rohan. That's not her liabilities.
These are, I think, sole interpretations that you're making. Uh, Ca- Mr. Gonsalves only made a will that in which he gave the house to Miss Samrita and the west side to Captain Rohan. All of these are just interpretations that you are making upon the will, which cannot be testified by late Mr. Gonsalves himself.
Miss Amrita, would you like to negotiate with
Um,
this?
agreeing to this, to my counsel, Miss Amrita, would you like to continue?
As for the Munkar claim, I think that I would like for it to be resolved before we sign any official partition agreement. And as for the resolution, I'd be willing to help, but I think the lion's share of the burden should fall on the contractor who is looking to build a hotel on the ground. I would I would prefer if I wasn't overly involved with it. But if you do require a little bit of my help, I would like to know what exactly you require, and then we can move on from there.
Um, uh, Dr. Amrita, we would be taking the sole responsibility of the Munkar if you agree to give us 50 lakhs OVLT and that also grossing up the official transaction value. So, would you be ready for that?
All right, I think that's a fair. Uh,
So, if you will be giving up the 50 lakhs OVLT, uh, also grossing up the official transaction value, so we will be taking the claim of Munkar. Would that be fine, counsel? As per the legal terms?
Yeah, that will be fine. So for the OLG 50 lakh with the tax is done.
Can I have
I
2
will
minutes?
hand over to my counsel over that if there are any other issues.
Can we have 2 minutes to discuss with Captain Rohan?
Yes.
Aroma, if the party wants to discuss, can you facilitate a discussion for them because they cannot just discuss on their own.
Yeah.
Yes.
Hello, yeah. So I had a talk with Captain Rohan. Um, 50 lakh, the amount which has been agreed to. I have to clarify that this is without tax. 50 lakh in hand.
Also, basically, grossing up the official transaction value to make it clear to the parties. That means that even after deducting the tax, that is 20.8% TDS, we will be getting 50 lakhs. And as per my counsel, it is legally valid.
First of all, I would like to say that OLT charges. On what basis OLT is 50 lakh? And secondly, if we agreeing to 50 lakh, then it is from the practical commercial value from the transaction and tax system. Then only we can transfer the 50 lakh OLT to you. Otherwise, 50 lakh in hand is not possible, Mr. Rohan and council.
Clarifying again that 50 lakhs grossing the value means that you will be giving, for example, you will be giving us 20, adding 20%, 20.8% to it. So you will be giving us, say, and or approximate amount of 60 or say 58 lakhs. And that will be in reducing the 8% tax. We'll get in hand that is the 50% tax. So even after reducing the tax and following all the legal compliances, we at the end the party will be getting the 50% tax, 50 lakhs, 50 lakhs, reducing the tax amount. So we are asking for that tax amount, and as you are asking continuously on the same point that on what basis we are asking this 50 lakhs. So this 50 lakhs is because your portion of the land has the roadside, your portion of the land has the house that has the 70% of your value, and your portion of land also has the west, has the functional well. So because of all this, we are asking this 50 percent, 50 lakhs OLT, and as agreed by Ms. Amrita, that we are able to take up the Mundkar claim if this 50 lakhs OLT payment is being guaranteed to us on grossing up the transaction value.
Okay, I would like to clarify the demands as of now. We demand 50 lakh OVT, that is 50 lakh in hand, plus the tax that will be 20%. So the amount goes around 60 lakh, which Mrs. Amrita will have to pay. If we get this, then we are ready to take complete liability of the Munkar claim. We are ready to let go of the 2 cents issue.
Okay. Responding to your offer, I would just like to kindly request the party B to consider my financial condition, my financial constraints. Would it be fair if I paid a total of 55 lakhs, subject to 20.8 of tax deductions, and giving you a 6-meter access to the West Side Gateway and access to the functional well as well, given that you take care of the 2 cent claim and the Mundkar claim?
um like I'll agree to all those conditions over there except the 2 cent claim. So as mentioned earlier as well, that it benefits the entire property. So I would request that that 2 cent claim can be divided into both of us, that you take 1 cent, I take 1 cent, and the whole property division comes to 20 cents of total from 22 cents. So would
Mr.
that be a fair deal?
Mr. Rohan, I would like to again share my client's views on this. That she has agreed on 55 lakh OLT. With reduction, it will be 50 lakh for you. And then also about the easement access, we are also providing a 6-meter access. Also considering the privacy and security of my client. And another thing for the 2 cent, Mr. Your the learned counsel says that said earlier that for OLT to receive for 50 lakh, they will take care of the 2 cent alienation by yourself. So, and over here you're again claiming 2 cent claim.
I am not sure. My counsel did not agree on the point
Just a
on
second,
two
just a second.
cents.
To clarify, what I said is that if we get 50 lakh in hand, complete 50 lakh in hand, then we are ready to take up these issues on ourselves.
So we have increased our royalty to 55 lakh, which will in hand you will
No,
get
55 lakh, that is, we don't get 55 lakh in hand. 20% TDS will be deducted from it.
Over here we are for the negotiation, and it would be very considering of you to negotiate it fairly, because my client's view is not for amount 50 lakh. It's not about like you get 50 lakh, it's about her that she is investing 50 lakh from her side, but now she has increased it to 55 lakh. So somewhere we have to settle this.
I'm so sorry, counsel. I hope there is some sort
And
of.
again, I'm very sorry to interrupt you, Aruma. How much time do they have left in their negotiation? This thing.
They have 2 minutes and 30 seconds left.
Yeah, so you have stuck to just one issue of the whole thing, your OVLT and this thing. You have stuck to just one. You have many issues. We would like to see how well you have encompassed all of your issues into your answers, and you're just deadlocked on one solution where you have gotten two solutions. You're not choosing between them. Negotiation is all about giving each other the best interest in a way that both of you benefit. So on the please ask the other judges for a couple of minutes of extension, and please get to the other issues, because otherwise we won't be able to mark you very fairly that you have not encompassed all of the issues.
Ma'am, we would request just 5 minutes extension. for the negotiation round.
Other judges, do you have any issue with the extension request?
Roma, how much time do we have left?
They had to.
In their active negotiation phase, they have 2 minutes and 36 seconds left. If the judges agree, they can ask for additional 5 minutes to wrap up their other issues.
5 minutes is too much. We can give 1 minute to each party so that you can just summarize whatever issues you have. I think that would be fair. Yeah.
Thank you so much, ma'am.
So you have 4.5 minutes now, and please be considerate now.
Okay, so for the OLT, we would like to negotiate on this part.
So basically, Dr. Amrita, she just agreed that she will be giving 55% of ability with the tax. So we agreed to that. If she wants to keep it at 50% with the tax, we are ready for that. 50 lakhs with tax, we are ready for that. We are ready to take the Mundkar claim. And we are also ready to build the privacy wall. But the last request, that is the last issue that we are having on hand, is that the 2 cent deficit. So my request to her was that the 2 cent deficit, we can have 1 cent each, and the total value of the whole land will be reduced to 20 cent. So it will be 10 cent to the west side, 10 cent to the east side, and 1 cent deficit to the each side. So
Right. I sincerely thank you for this generous offer, and I agree to all your terms, and I agree to share the 2 cent deficit, dividing it 1 cent each.
Just to finalize, the OLT payment, are you agreeing for 55 lakhs or 50 lakhs?
50 lakhs with TDS and the 2 cent sharing.
Okay, agree to that. So the council, can you just summarize all the points of that?
Yeah, so over here we are agreeing for the 6 meter easement access, and that 55 lakh for the OLT, and for the 2 cent deficient also 1 cent we will keep, and 1 cent yours, and also the privacy wall will be framed.
Yes, the privacy wall.
And the Mundakar claim.
Yes.
So for the Mundakar claim, we suggested for the developer to help in that case.
Sorry.
Okay, so we will take the responsibility for the Munkar claims. So just to be clear, both the parties get a clear title to their land holdings. West side gets a 6 meter non 6 meter wide path without any hindrance from the south gate. Captain Rohan gets a 50 lakh OLT, that is including the tax. Yeah, that's it.
Okay.
And there are 2 cents which have been there. So these 2 cents get divided between both the parties equally, making now the property share 10 cents to each the party.
Agreed.
So if everyone agrees on this, so we'll thank you for the negotiation session over here. And as the party has agreed for the agendas discussed today, so the contract will be signed, and it will be binding on my client and also on Mr. Rahul.
Yeah, I thank you so much for the council, and also Dr. Amrita for being so kind during the negotiation session. Also, I would request her to please try to do the payment as soon as possible, hopefully in a 30 days window. And I will really look forward that we sign this particular agreement and be binding upon its terms. Thank you so much.
Can I take for just 1 second? We have agreed to a clear title for both the parties. This means that the Section 44 TPA, which has been enforced by Dr. Amrita that will be taken care of?
Um, we're willing to withdraw those claims if Party B is willing to withdraw their inventory proceeding.
Yeah, definitely.
Done. Agree.
All right. Thank you so much for being with us here today. Thank you for engaging with us today. Throughout these discussions, both the parties have consistently demonstrated their willingness to preserve the testamentary agreement and avoid prolonged litigation. And we have reached a decision that has been that will benefit both the parties equally and fairly. Thank you so much.
Thank you.
That brings us to the conclusion of round two to UIC 02 and UIC 04. Congratulations on completing your negotiation. It has been a pleasure watching both of you engage with the problem so thoughtfully and professionally. The preparation, confidence, and adaptability you brought to the table were evident. Regardless of the results, we appreciate your effort and skills. Thank you for being a part of this round and for making it such an engaging one. We wish you both the very best. I would like to request the judges to fill in the score sheet, and if there is any discrepancies or as needed, kindly reach out to the organizing team.
To the organizing committee, can we request the judges to give us feedback? Ma'am, can you?
If the judges may like, yes.
Not
The
yet,
judges'
Rome.
discretion.
Actually, let the judges first.
We will have a round. We will have a round at
Yes,
the end of
at the
the
end. Yeah.
session. Yeah.
Completely open.
Okay, so the participants can leave for now then. Thank you.
Thank you so much.
I request all the judges to inform us once they are done with the scoring so that we can ask the participants to rejoin for the feedback.
Judges, if it's okay, can we ask the participants to rejoin?
Yes.
Okay.
To all the participants who have joined, please ask your partners who are not here to kindly join as soon as possible. And please switch on your cameras. UIC 4 and UIC 5. Are your partners joining?
Let me just ask her just a second.
Yeah, she's joining, ma'am.
Okay. Okay. So I guess if it's okay with the judges, we can wait for 1 or 2 minutes for the last two participants to join, and then we can commence with the feedback. Is that all right?
Sure.
Thank you.
Hi, I'm currently unable to reach my partner. We may begin.
Welcome back, everyone. I now open the floor for feedback from our esteemed panel of judges.
Kajal ma'am, Vasanta ma'am, do you want to go first?
Yeah, I'll go ahead first. Thank you so much, everybody. I think it was a great effort by everybody, either side. I think it was a great effort from all of you. And to give a more specific feedback, the teams that appeared in the first round, I think you did a really great job. You took help from the case laws, from the legislations as well, which was quite good. And but if I had to give like one critical opinion here, it would be that try not pointing out the other party's mistakes, because if you do that, if you say that this is something that belongs wholly and absolutely to one party, it would end up becoming a blame game only. But if you are here in a negotiation and not in a litigation proceeding, it's better to take everything as a team effort, understand what the other party actually requires from you, and then if that actually benefits you, only then accept it. Because we have arrived at a settlement point. That is good that we arrived at a settlement, but we arrived at settlement giving something which was probably more beneficial to us. So think double about what you're saying yes to, and then finally concede to it. But it was a great effort. And specifically for the teams in second round, I think what you could have done better was this, that I think the first round, the first level of the competition was the opening phase. Rather than just introducing yourself, you could have also introduced the problem and what would be the major issues that you would be covering up. Because utilizing that time was also very important, because that would have set up the stage really well, that this is what is happening here. This is something that we are looking forward to while we are working on the negotiation. We had basically jumped into an active negotiation phase because we did not discuss what are the issues here, what are the complications here, what do we actually want from the other party. So it would be a good practice, at least in the practical world, it would be obviously a good practice to consider what the reality of the situation is, to consider what your expectations are, and then sit down, jot down what do you actually want from the other party, rather than saying this is something we want, this is something we want. There would be a fair trade of everything. And obviously there was a bit of time lost there, but I guess we did not, for whatever time we lost in the active negotiation round, we came on a really swift settlement in the third stage. But yeah, I think we could make a little more use of the legislations that we were given, and obviously of the case laws as well. Otherwise, it was a really good effort. Great work.
Vasundhara ma'am.
Thank you, Kajal ma'am. Vasundhara ma'am, Pranavi ma'am, whoever would like to go next, please.
Okay, I guess Vasundhara ma'am is engaged somewhere else. So let me start by the first round, the first team that we adjudicated. I would like to start with team one. You were good. There was a lot. There were a lot of case name droppings and a lot of rules as well that you had read. So that actually gives you a step ahead, because it tells the other party that you have come prepared. But in this round, I saw in actually both the rounds, I saw that you people saw, participants saw this competition as how to attack each other and how to get more marks over here. But no, actually these kind of competitions, any mediation competition, any negotiation competition, these are all adjudicated as to how you are giving each other the benefit of doubt, and how you're getting each other's best interests fulfilled. That is what people actually want to see. Because what are all these coming under? These are alternate dispute resolution. Okay, this is not adversarial moot court competitions where you have to just shoot the other person down. So please keep that in mind, that for the next time that you go for any of such competitions. I actually had a problem with the team 5 where they kept on mentioning the North Gate, and the team 1 also picked up on it rather than correcting it, because there's no mention of a North Gate in the hypothesis anywhere. Okay, and that is one of the issues. Secondly, I thought was that you missed out on a lot of points. Okay, you missed out on a lot of points looking at this, at the one or two specific things that you wanted to prove. You missed out on a lot of points. Like the CRZ was not mentioned till very late. You did not get a resolution at the end. You were still stating each other's interests, that I want this, I want this, but there was no meeting of the minds. There was no agreement over there. So yeah, next time, for other than that, I really appreciated and I really liked the way that you guys presented yourselves, your communication skills, your preparation was spot on, and I wish you all the best for the other competitions and all the other endeavors that you would wish to go for. And that's it. Thank you. As for the other team, I thought that your agreement was settlement agreement was more nuanced. It had more pointers to look out for. It you came into an agreement almost in the within 15 minutes of your this round it started, but you missed out on the introduction and the facts. Okay, you missed out completely. I completely missed out on that. I never got to know what was your partner, sorry, I mean, client facing problems with. What was the situation? You have to explain that, right? You have to tell us the background of the situation, because think of us as people who do not know the hypothesis. Okay, you have to summarize the introductory part for us first, and that's what shows your time management. If you would have given us a bulleted point this thing as well, we would have loved it. But then you jumped into the both of the parties just jumped into the negotiation part of it. Okay, and second was that, I'm sorry, I actually would be deducting some marks for yeah, for team code 4, because there was a lot of cutting each other, and putting your view forward, your point forward, like you attacking. It felt like attacking. That's not what these competitions are about. You have to. It's fine that you gave space for each other to talk. That is very good, but you ended up attacking each other. That no, that's not our problem. That no, we do not agree with this. That is not what is supposed to happen. And for that, I would really like for you to keep an eye on such situations for the future. Other than that, I really thought the second round was much more clear on the teams were much more clear as to what they wanted. The first round had a lot of cases, names, a lot of background information that you had cleared up before coming here. But round two had a lot of more discussions and a lot of more coming together with each other and reach an agreement. So these were very good rounds. Actually, it was a very good competition for me to witness, and I'm glad that I got to hear you all, and I really wish the second round teams as well a very best of luck for your future endeavors.
Thank you, ma'am.
That we conclude the semi-final rounds for the contract negotiation competition hosted by DLRC under NLRC WICCI. The results for the semi-finals will be announced by tonight. We appreciate the commendable performances given by all participating teams and are grateful for your participation. We are also grateful to the NLRC President Vaishnavi ma'am and Vice President Adrika ma'am who guide us throughout the event. To our esteemed judges, on behalf of the DLRC and the NLRC WICCI, we extend our deepest gratitude for your time, your expertise, and your commitment to shaping the next generation of legal professionals. Your presence has made this competition truly special, and we cannot thank you enough. Thank you once again, everyone. It has been a privilege hosting you today.
Thank you.
Thank you.
Thank you so much.
Please, I request the judges to please stay back and rest of the participants can leave. Yes, you, I see you too.
I just wanted to ask, ma'am, that like two things. One is that should we use case precedents while a negotiation, because a negotiation is supposed to be between the parties and usually the layman parties. And like, ma'am, second thing, that is the negotiation confidential information is shared beforehand to the parties, because this is first time I'm seeing that negotiation confidential information was shared beforehand to both the parties.
In such competitions, it is actually shared with you beforehand. No, not the earlier when you're getting this registration and all stuff. Nahi. Once you are near to the competition, you're given this information because you want to see how you leverage that, how you use that in a way that other person does not get to know, and you save yourself from any problems that you might face, because there's some complications not in your favor and there were some complications which were in your favor. How you use them, how you make sure that you do not let the other person know, other party know that you have any weakness as well. You want to see that. So yeah, that's why the confidential information is given to you. And about your second question,
Ma'am, like just a clarification, like the confidential information indeed is given, but in this case, the confidential information of both the parties were given to each other. So that hypothetical docs, party A confidential information was also available with party B, and party B confidential information was also available with party A. And if there would be, in such case, if some information is given, there would also be some kind of additional information that requires to be there. So, for example, now I already know what Amrita A's problem, like party A problem is there. So I already know her confidential points. So then that is one thing that I was not clear about.
if that is the case, next time you can ask the organizing team directly if this was a planned move or if this was a mistake. And I'm not sure here what they wanted to do, but it's fine. It's fine.
So, ma'am, like just asking you so that other parties' confidential information is also shared or not, because I've not been in negotiation. It is not.
Generally, it's not.
It's not. And ma'am, the second question, case precedence.
Yeah, okay. So, in the other teams as well, they were not dropping a case name every two lines. No, no, no. If they had to ask for something, for example, that, I'm just giving an example. I'm not saying that they said this in their arguments, that we want to get an easement of 6 meter, that door access that you want. So you can, cite a case where an easement was given to someone after partition to support something that you are asking for. And it's not like you just have to make a line of 10, 15 cases, a big note, you have to just give it to us. No, no, that's not that. You have to mention it to facilitate your work, and you have to strategically put it in between in a way so that the judges appreciate that you went out the extra mile, you went a little bit further in your research. That's it. Nothing
Okay.
other than that. You don't have to make it showy, because this is ADR. This is not a moot court competition, right?
Yes, ma'am.
To make it showy, you just have to find out, creative and unusual solutions to your problems and just support it by a case law.
Okay, ma'am. Thank you so much.
Please take care.